Mr. Chairman, Ranking Member, members of the committee, thank you for the invitation. In my allotted time, I'd like to take a few points from the statement I've submitted for the record. I've made two overriding points in that submitted statement. First, if Judge Kavanaugh joins the court, it will be the most presidential powers-friendly court in the modern era. Republicans and conservatives only a few years ago, I know well, fought the expansion of presidential power and executive powers. That's no longer true. Judge Kavanaugh has a very broad view of presidential powers. For example, he would have the Congress immunize sitting presidents from both civil and criminal liability. Under Judge Kavanaugh's recommendation, if a president shot somebody in cold blood on Fifth Avenue, that president could not be prosecuted while in office. Also, it's not clear to me, listening to the testimony, that he really believes Nixon, or U.S. versus Nixon, was correctly decided. A second general point from my submission, a very vital, I think, process point. Ranking Member Dianne Feinstein stated on the morning of September 4th, just before the hearings opened, that after participating in 9 Supreme Court confirmations, it had never been so difficult to get access to background documents relating to a nominee as in the current proceedings. Unsuccessfully, the minority sought to postpone these hearings until all the requested documents were provided. The chair, however, declined to consider the motion that would make review possible. This committee is deeply involved in the final phase of vetting Supreme Court nominees. Based on personal experiences with the confirmation, for example, of William Rehnquist and studying the confirmation of Clarence Thomas, it's clear there was an across-the-board failure to fully vet the nominees, and it has haunted their careers on the court, it's hurt the court, and the American people. Because of the withholding of documents, Judge Kavanaugh may be traveling the same path as Rehnquist and Thomas. When writing a book that I did several years ago, The Rehnquist Choice, I explained how Rehnquist was selected by Nixon as one of the for two openings that occurred in 1971. I also reported my sad discovering that Rehnquist had dissembled during his confirmation proceedings. He did, however, notwithstanding false statements, become an Associate Justice. When Ronald Reagan nominated him to be Chief Justice in 1986, again, he was not vetted, and in those hearings, he was confronted not only with his earlier false statements, but new material that resulted in new false statements. All the court historians that I have examined and court scholars find clear and convincing evidence that Mr. Rehnquist lied at his 2 confirmation proceedings. This hurt him and it hurt the court. Because Justice Thomas was not fully vetted, his career in the court has been under a cloud as well. Thomas's truthfulness vis-a-vis Professor Anita Hill's claims of sexual harassment have never been fully resolved, nor has the controversy ever ended. A definitive study of this controversy was undertaken in 1994 by journalists Jane Mayer and Jill Abramson, Strange Justice, The Selling of Clarence Thomas. They found a preponderance of evidence supported Anita Hill's claims. This controversy has received renewed attention with the Me Too movement, which is growing stronger and it's not going to disappear. In fact, Justice Thomas's truthfulness is an issue in this year's midterm election. A Democratic candidate in Massachusetts has made an impeachment of Thomas for his false claims during his confirmation one of the planks of her campaign. In closing, Judge Kavanaugh's nomination has raised issues about the truthfulness of his confirmation to become a judge on the D.C. Circuit. His answers to this committee have not resolved the issue. Frankly, I'm surprised that Judge Kavanaugh is not demanding that every document that he's ever handled be reviewed by this committee, unless, of course, there's something to hide. Thank you.